We're going to talk about discharge of contracts. Discharge of contracts means putting an end to the rights and duties created by a contract. A contractual condition is the occurrence or non-occurrence of an event that is expressed in a contract and affects the duty of a party to the contract to perform. There are three classifications of contractual conditions: a condition precedent, a condition subsequent, and a condition concurrent. Condition precedent. An example would be a real estate contract frequently is conditioned upon the buyer obtaining financing. So for condition precedent, the condition has to be met before the contract obligations are required to be completed. So Fisher promises to buy Calvin's home if Salvation Bank approves Fisher's mortgage application. Thus, the Fisher-Calvin contract is therefore subject to a condition precedent, the bank's approval of Fisher's mortgage application. A concurrent condition exists when each party's duty to perform is conditional on the other party's absolute duty to perform. An example is if a buyer promises to pay for goods when they are delivered by the seller, each party's absolute duty to perform is conditioned on the other party's absolute duty to perform. Normally, contracts are discharged by performance. When performance occurs, the obligations of the parties end. Sometimes, however, the parties do not perform in a timely or satisfactory manner. When the time for performance is not stated in the contract must be performed within a reasonable period of time. Usually, this is a question of fact for the jury to determine. If performance of the contract on or within the exact time specified in the contract is vital, it is said to be time is of the essence. In this case, the time for performance will be strictly enforced. When a contract fixes by clear language a time for performance and there's no evidence showing that the parties did not intend that time should be of the essence, failure to perform within the specified time is a breach of contract. Adequacy of performance. Complete performance occurs when all parties fully accomplish every term, condition, and promise to which they agreed. Substantial performance occurs when a party in good faith executes all promised terms and conditions with the exception of minor details that do not affect the real intent of their agreement. Effective substantial performance. The measure of damages is the cost to bring the object of the contract in compliance with its terms. If the cost is unreasonable, the measure of damages is the difference in value between the performance rendered and the performance that would have been rendered if the contract had been completed fully. And performance to the satisfaction of the contracting party. Contracts often state that completed work must personally satisfy one of the parties. When the subject matter of the contract is personal, a contract to be performed to the satisfaction of one of the parties is conditioned, and performance must actually satisfy that party. Dissatisfaction must be made in good faith. Examples include contracts for portraits and works of art. Contracts that involve mechanical fitness, utility, or marketability need only be performed to the satisfaction of a reasonable person. Construction and manufacturing contracts are usually not considered to be personal, so the party's satisfaction is normally irrelevant. During contract negotiations, parties may agree to certain terms that provide for automatic termination of the contract. Discharge by impossibility. One way is destruction of subject matter. When the exact subject matter of a contract has been selected and designated by the parties and is later destroyed, the performance obligation is discharged or terminated. In contrast, when the contract is not specific in the description or the location of the subject matter, a promisor is not discharged if the subject matter intended for delivery is destroyed. In this case, the promisor is obligated to locate and deliver the subject matter of the same kind and quantity that could be secured elsewhere. Another type of discharge by impossibility is when the performance of the contract is made illegal through the passing of laws subsequent to the formation of the contract. The contract is declared void and the party's contract is discharged by a change of law. The death or disability of a party obligated to perform an act that requires a special talent or skill terminates and discharges an agreement. Examples: promises to perform by musicians, artists, and writers. This rule does not apply when the contract relates to services that may be performed by others or the contract terms indicate the continuance of the obligation after the death of one of the parties. Bankruptcy ordinarily eliminates contract claims against the debtor. The statute of limitation provides that after a certain number of years have passed, a contract claim is barred. Some contracts, like insurance contracts, contain a time limitation within which suit must be brought. This acts as a private statute of